Hey folks, Dale Davidson here today. Thank you for joining us. So today's topic, these online document assembly services for your will, your durable power of attorney, your health care, your living will, all of those things. A lot of times, they're good services, but a lot of times they're my best referral sources, and I'm going to tell you why. Okay? Why? Because of the drafting mistakes. Now, these systems are trying to cater to the mass, okay? So they're putting stuff in a will or asking you to put in stuff in a will that doesn't need to be there. Sometimes you cause two probates, husband and wife. That's a big issue. So templates are just not all the what they're cracked up to be. Now, there's different types of wills. There's, of course, the written will that we're talking about, but then a lot of people do these handwritten wills, and they are called holographic wills. And they're okay also, but they still must comply with state rules. They've got to be executed in a certain way. You got to have so many witnesses. You got to notarize and all that, but you still got to be careful about what you put in a handwritten will. So regardless of whether you're using a template will or a handwritten will, there are several items that don't need to be there. Number one, funeral arrangements. You know, it's not a good idea to put your funeral arrangements in your will because you're gone, you're buried 6 feet underground, and then a week later your family opens up your safety deposit box and your will says that you want to be cremated. That's a problem, okay? So don't put your funeral arrangements in your will. The best solution there, go prepay your funeral or make your arrangements ahead of time. Make your wishes known to your family. Once you've done your prepaid, and I'm a big fan of prepaying for your funeral arrangements, then tell your family and have that documentation available to them, okay? Number two, organ donation. Now, I'm a big proponent of organ donation because organ donation save lives. So I'm in favor of this, but they should not be in your will. Again, why? For the same reason your funeral arrangement shouldn't be. What happens if you're passed away and you wanted your body donated to the Medical College of Georgia or whatever for medical purposes, but then you're cremated? Wow. But that was in your will, but now your body's not available for medical. So again, don't put it in your will. Solutions, do it online at the Office of Motor Vehicles in your state. Okay. A lot of times these states will put it on your driver's license. We put that kind of information in your living will. In Georgia, we call it a Georgia Advance Directive for Health Care. Okay, but make your wishes known to your family, okay, and your healthcare providers. So communication is the key to here, okay. Number three, designating in your will who gets your retirement plan, your 401k or your IRA, okay. Doesn't work. Okay, why doesn't it work? Because your beneficiary designation should be on file with whoever the plan administrator is for your 401k or your individual retirement account, okay? Because that beneficiary designation controls where those funds go, not your will, because now when you do a beneficiary designation, that is a contract with your plan administrator or the plan sponsor saying that upon my death, I want my spouse, my children, whoever it may be, to get my benefits under this plan. So if you don't have a beneficiary designation, then you have to look to the default rules under the plan itself. Because again, the plan is a contract between you and the plan itself saying that if I die, if I don't have a beneficiary designation, then it goes by this default rule. Generally, it's spouse, lineal descendants, meaning children, and then your estate. Okay, never ever name your estate as a beneficiary of your IRA or pension plan, okay, unless you want your heirs to pay a bunch of income taxes. I'm not sure of anybody who wants to pay more income taxes than they're supposed to. Okay, now caution here: if you have been divorced, very carefully think about this. Make sure that your beneficiary designation is up to date. Okay. In fact, we talked about protecting your assets in a previous video. It's top divorce tips on how to protect your assets, and I'll leave a link right here for that. But that talks about, look, make sure that your ex-spouse is not named as your beneficiary of your 401k or your IRA, because upon your death, it's going to go to whoever that beneficiary is. Now, if that's your ex-spouse, guess who's going to be really mad at you? Of course, I know you're not going to be here, but who's it going to hurt? It's going to hurt your current spouse. So always make sure that your beneficiary designations are up to date on your IRAs or 401ks. Never ever designate your estate. All right, number 4, don't put end-of-life decisions in your will. Solution: put them in your living will or advance directive for healthcare. Why would you not put that in your will? Well, for the same reason you don't want your funeral arrangements or organ donation in your will. If you're in a hospital and you're being kept alive by life-prolonging procedures, and all of a sudden your family says, well, let's go ahead and disconnect Dale from that. Well, the problem is my will says that, hey, if I'm in such a condition and I'm being kept alive by artificial means, I want you to do everything that's humanly possible to keep me alive. But guess what? Now I'm not. Okay? So put it in your living will or your advance directive for healthcare, not your will. Okay? Number 5, setting up a trust to avoid probate. Guess what? The trust needs to be funded during your lifetime to avoid probate. That's the number one reason why these revocable trusts don't work. Because guess what? You've got to fund them during your lifetime. If you don't, then we still have, if you've got real estate or anything, we still have to go through that probate process, okay? So what a lot of people do, depending upon your state now, they'll set up a separate trust during their lifetime. They call them revocable trust or living trust, something of that language, okay? But we still have a backup called a pour-over will that says if you haven't put something in the trust that needs to be probated, then we still have the will there as a catch-all to pour that over like a pitcher of water into the trust, okay? So very important that everything is funded during your lifetime. So hey, check your checking accounts. Make sure that the checking account is in your trust. Make sure that your savings account's in your trust. Your brokerage account is in your trust. Do not put IRAs or 401ks in your trust. Never, ever, ever do that, okay? Make sure your real estate. Got a client down in Hillsborough County, Florida. They have 2 houses in different states. Found out yesterday after amending their trust from a different attorney, neither one of their parcels of real estate are in their trust. So we're having to now do some deeds to transfer the property in there. That'll make them work, okay? Now, number 6 mistake not to do, okay? Designated individual properties that you've got in some kind, maybe you've got an LLC, maybe you have some rental properties, they're in an LLC or some kind of partnership. And you say, well, I want Susie to have the house on Main Street, I want Jimmy to have the house on Devereaux, whatever it may be, but they're in that partnership or in that LLC. Those are separate entities. You can't do that. Well, you can, but it'd be a mistake. Okay, so you got to look to the LLC operating agreement or the partnership agreement, because that controls the disposition of those properties. So just because you want Susie to have this one and Jimmy to have this one doesn't mean that they're going to get it, okay? So what's going to happen on your death, there's got to be some kind of direction or mechanism for the LLC or the partnership to distribute the properties to you, to your estate, okay, or trust or whatever you've got, and then that distribution from your estate or trust to the children, okay. Complicated, yes, but you've got to make sure the title is correct, okay. Number 7, never leave a reason why you're leaving a specific bequest to somebody or a child. Well, I'm going to leave my jewelry to my daughter, Sarah, because she's always admired my jewelry. Well, your other daughter, Betty, might have admired them, from afar, but she never voiced her opinion. So why, just because one daughter has admired or voiced her opinion versus the other one, just leave it. Just say, look, I'm giving my jewelry to Betty or Julie or whoever it may be, but don't give a reason, okay? That's all. Reasons are better left unsaid. You're in an emotional state as it is, so don't add to that, okay? Number 8, and our final one. Don't leave life insurance policies or annuities, okay? Now, we talked about beneficiary designations for an IRA and a 401k. Now, just like that, beneficiary designations for your life insurance or annuities control the disposition of that asset, okay? So check your beneficiary designations, okay? You don't want life insurance paid to your estate, because then that money then is subject to claims of creditors of your estate. Likewise, if you have your annuity paid to the estate, then you've got all kinds of income tax problems there. So beneficiary designation controls, and again, if you've been married more than once, make sure that designated beneficiary is current. If you want your ex-spouse to have something, that's fine, but just check it, okay? Don't designate your estate, because doing so will cause all kinds of issues. Hey folks, thank you for watching. I talked about this video earlier on. Here's a link to it. It's called Top Divorce Tips, How to Protect Your Assets. That goes well with this video as far as trying to make sure that your beneficiary designations are correct on all of your assets. So please hit that link, and until next time, you be blessed.